and everyone's coming in now. Okay, Elizabeth, everyone from the waiting room is now in the meeting.
Great, thank you. All right, hello, everybody. This is the July 31st, 2025. It's a public hearing that was called on an emergency basis. There are 3 items. The first is to review a suggested revision of the Preservation Commission's rules and regulations. The second is an executive session regarding 45 Beverly Road. And then finally, a public hearing regarding 45 Beverly Road. And this meeting was called on an emergency basis at the suggestion and direction of, I believe, of John Buckheit, Town Council, and Kara Bruton, Director of, I'm going to get your title wrong, Sarah, Director of Planning. And you can elaborate on that. But I've asked, I think first Kara is going to speak, and then John will speak about to help everyone understand why they requested that the Preservation Commission meet on an emergency basis.
Thank you, Chair Armstrong. So my name is Kara Bruton. I'm the Director of Planning and Community Development. I have been in conversation about 45 Beverly specifically, just in the last couple weeks with other staff in our department and with Sarah Kaplan, our building commissioner, Sarah Kaplan, who is our ADA coordinator, Dan Bennett, who is our building commissioner, and John Buckheit, who's here from Town Council's office. And in getting up to speed on the correspondence to date with the applicant for 45 Beverly Road, and also understanding that the Preservation Commission is fully booked with their normal business and would likely not, in even a normal meeting, had to be pushed until after August 20th, it's my understanding. After talking to John, asked Tina to do anything she could to get a meeting set up just to deal with 45 Beverly Road as the thing that needs to be disposed of sooner than later. And in those conversations, the staff have talked about all different kinds of combinations of ways that the commission could move. And I don't want to get into the specifics of 45 Beverly until we go into executive session. But I will just say that I am not looking for the Preservation Commission to necessarily make any even significant discussion on changing a policy within one meeting. My goal for today's meeting is to deal with 45 Beverly Road specifically. John, did you want to add anything to that?
Yeah, I just want to add that so we're kind of in an interesting place procedurally here. As you all know, we had some new bylaws that passed in the Springtown meeting. Those are both currently being reviewed by the Attorney General's office. Anyhow, so neither of them have been approved yet. The zoning bylaw that was approved, which really isn't your concern. This particular project, 45 Beverly Road, doesn't require any zoning relief. So that provision isn't impacted. Interestingly, the second warrant article, which made the change to the demo delay bylaw, it added section 5.311C. That won't become effective until the Attorney General approves it, and that has not occurred yet. So we're in this place that, even we don't have any specific bylaw that bears on this issue. Nevertheless, I think as most people know, that we still, if a reasonable accommodation has been requested, we still have to consider it in a timely fashion and make a decision. And that kind of brings us to where we are right now.
So in terms of a timely fashion, I'd like to have a better understanding of what, if any, timelines we're operating under pursuant to the American with Disabilities Act, the Fair Housing Act, et cetera. Are we, are we operating under a timeline that's more specific than in a timely fashion?
Yeah, I don't think there's a specific, I think it has to be done promptly, but I think in my opinion that varies a bit depending on the accommodation that's being requested. There is a general rule that within 30 days that it be dealt with. However, in a case like this where I think the developer is still developing building plans for the replacement structure that they're seeking to build. I think it might be a little bit, that might influence it. There might be a little bit more time, but.
Well, when was the reasonable accommodation requested? What was that date?
No, I don't have the specific date. There was,
John, I'm happy to step in if you'd like me to.
Sure, that would be, do you have that? So everyone, this is Michael Ross, who's the attorney representing the applicant here. I'm sure, Michael, if you have that answer, that'd be great.
Yeah, thanks, John. The initial letter was sent on May 29th, approximately 60 days ago. I could kind of walk you through the sequence if you'd like, Madam Chair.
Well, let's hold off on that a bit because, and while we certainly want to hear from you, we are going to talk more specifically about your applicant that you're representing. And I think maybe so let's hold off on that for a bit.
Sure.
Yeah, I think we should wait until executive session, probably to.
Yeah, that's what I was wondering. All right. So I think we've all received the document that was posted that's titled Reasonable Accommodation Process, Demolition Delay Bylaw. And my first question is, who drafted this? And who was the audience? Is the audience the Preservation Commission or a broader audience?
So the audience was internal to staff. So that all of the staff haven't even been able to digest that draft. You'll notice, for example, where that it talks about, who might the commission, if they wanted to not deal with a full demolition case like this every time it's requested, they could authorize the chair, they could authorize anybody on staff to do that in that limited time frame. But we haven't even had the discussion amongst staff of whether that makes sense, who it should be, in what conditions. The title of the document was something that Tina had drafted. Again, this was, an internal document. There was another version that was internal that tried to mirror, and Tina's done so much work on this, and it tried to be a parallel track of the interactive process that was set forth in Warrant Article 14. And so, for example, in that first draft that Tina had offered, there was a lot of steps requiring the building commissioner to take certain actions as part of that interactive process. And I took another stab at it, not requiring, for example, his participation in order to get something to move forward. But again, this is something that needs a lot more discussion with you all, but I think only if you all wanted an option that wasn't your normal operations, which is to have a public meeting.
Hey, so from what you said, the level of preparation and internal review for this document to date, it doesn't seem that it's in a posture that anyone could expect the Preservation Commission to adopt it in any form when it's it's in, you know, it's in media res. So I think it's helpful, you know, I think there was some confusion with the commission about, you know, how are we supposed to regard this document? So it sounds like it's, you know, it's working on a policy, but it's not ready to be incorporated into our rules and regs. And I would agree with that. From my review of it, it's not something that I could support incorporating into our rules and regulations at this time. I think I want to just talk just for a minute to kind of remind the commissioners and anyone in the public who maybe hasn't been living with this matter as much as we have. So the town of Brookline is in need of policies and procedures so that we can, so that when a person under the ADA or the Fair Housing Act, or there's some other statutes as well, when they ask for a reasonable accommodation, that that the town is able to supply them with a timely and administrative process so that they don't have to go through multiple commissions and public hearings and so forth. And this is a matter of federal law that preempts local law. So local laws, some of the local laws are not going to be followed to the letter, and that is the federal policy stated by the ADA and the Fair Housing Act. The warrant articles were introduced, warrant article 14 and 15 were introduced by Dawn Oates, who's on the call. Hello, Ms. Oates, to town meeting in May. Some alternate warrant articles were suggested that would to spell out a different kind of administrative process, but the town meeting adopted the warrant articles as submitted by Ms. Oates. Although I'm a little foggy, there may have been some substitution, but in essence, those warrant articles passed. However, they're not the law for Brookline yet, because they have to go to the Attorney General's office, who has to approve them to make sure that they're consistent with federal law and state law, and that they'll that there's no objection to them legally. So for that reason, we're not operating under those warrant articles as of today. We presumably will be in the future, as long as the Attorney General accepts them, maybe with or without modifications. I have no idea. But it would be, you know, again, in thinking about changing our rules and regulations, it would be premature for us to enact any change to our rules or regulations when the warrant articles have not been yet passed by the Attorney General's office. So I guess we find ourselves in a place where there hasn't been a specific town policy enacted or put into place that would govern what we're being asked to do today. But it seems that it's fallen on the Preservation Commission to make a decision in this matter. Having said that, I want to check in with the other commission members whether or not, I think the first matter is reviewing the revision of the rules and regulations. And I think for the reasons that have been laid out here, I would put forth a position that we can't, we don't want to, we're not in a position to change our rules and regulations today for to comply with a warrant article that is not yet fully complete and accepted by the Attorney General's office. Other commissioners, do you have a different point of view? Would you like to discuss this?
I wholeheartedly agree with you, Elizabeth. I think it would be prudent if we wait to make sure that, because anything that we do, if there are changes that are made, then we have to go through it again. And so it seems expeditious to simply take this case now to the best of our ability and wait to do the regs, rules and regs, and update everything once we know that everything's going to be in compliance, because rewriting and rewriting is a lot of work to put on the staff, and never mind the commission.
Thank you, Arisa.
I can-
Other,
Yeah, I agree with both you and Arisa. I had a lot of questions reading this. I was very confused in the beginning. I may be a little clearer now, having talked to people, but I would like to see whatever we do completely in the context of our existing rules and regs. I didn't know what this was, and being dropped in as some sort of change. And also, I think, for me at least, we, as a background, have a clear understanding of warrant articles 14 and 15, whether or not they're changed through the Attorney General process.
thank you, Elton. And if we're taking the position that we're not going to change our rules and regs today, I think we don't need to get too far into the weeds or spend too much time on this document, fine combing it today, because as Kara said, they need to do more internal review with staff. So let's see, Peter? Or David King, anything, any thoughts?
I agree with what's been said.
Okay,
Yeah, I have no other comments. Thanks.
okay,
I agree as well. It's logical.
thank you, Brooke. All right, so let me check in with Tina. Do we need to take a vote on this? The way
No.
that, okay,
It
all right.
just says possible vote, and that possibility has been eliminated by the discussion.
All right. Given that this is the position of all the commissioners, I think taking public comment is discretionary on this matter. I want people, members of the public, to be heard. But I think we will allow a limited public comment, but I just want to remind people that we just said we are not going to change our rules and regulations, and that this document that's been circulated is not in a posture to be adopted. So having said that, I'll ask Tina to instruct members of the public about if they wish to be heard, but I would like people to keep their remarks brief in view of the Preservation Commission's position on this.
Okay. So members of the public, you are welcome to notify us that you would like to engage in public comment now. The chat is available. Otherwise, the raise your hand function is the easiest way to get our attention. That should be located in the center of your toolbar at the bottom of the screen. You may have to hit the heart-shaped react button in order to get that hand option to come out. So that's just a little technical advice. Again, the chat is available. If you're having technical issues, you can message us there. And we do have a few hands going up for a brief public comment.
Yes, and I will just say, after this, the commission will go into executive session, and then we will come back out and have a public hearing on 45 Beverly Road, which we will definitely take public comment for that. So I'm just kind of reminding people that this is your opportunity to speak about the matter we just discussed, our decision not to incorporate or vote on a revision of the rules and regulations.
Yeah, I think any issues related to 45 Beverly will be dealt with later. So if folks could keep your comments limited. So the first hand up was Linda Olson Pelkey, and when we call your name, just unmute yourself, and you should have those controls. Go ahead.
Hi, thanks, Tina. Good afternoon, Preservation Commission. I'm not sure my comments are appropriately given now or later because it's kind of a blend of the two, so I'll try to be brief. I guess what I'm assuming that later in the meeting, you all are going to take a vote on whether or not to lift the stay of demolition and whether or not that lifting the stay is based on your findings and your usual process. But with the added twist that it would be in service to a reasonable accommodation. Do I have that right so far? Is that what's happening here today?
That's my understanding.
Okay, so I guess my first point would be that certainly I feel the abutters of 45 Beverly should have been notified. I don't know if they were or not, to allow them to speak their mind at this hearing. And in terms of the process and the bylaws we're trying to adopt and all of that, I would say that still the learnings that came out of that through the staff and everyone in the town council is that there needs to be a finding with the 4 points of what makes a reasonable accommodation necessary and reasonable. And I don't want to go over that unless it needs to be, but those findings need to be articulated and seen in this case. You know, that it's not deviating and controverting the town's bylaws and the public purpose of those bylaws, that it is absolutely necessary, that this particular accommodation is what is necessary to meet the needs of the applicant. And that, yes, in the future, a person with a disability will be living there and a couple other things. So, you know, we're not there yet in terms of the adopted bylaws or the process. And many of us still have some discomfort around the process that was adopted. And we think there needs to be a balance between keeping the privacy needs and meeting the needs of the disabled applicant, absolutely, but also keeping in mind the public purpose of what our bylaws are for and trying to meet those needs as well. So we always felt there was a balance needed. So I hope that that helps a little bit with your deliberations in this case. As you said in the beginning, there was no plans offered. So I don't think you can lift the stay based on what you know about is going to be built, because you don't know. So then that takes you back to needing to have the finding that the accommodation is both reasonable and necessary. So I will stop there. Thank you very much.
Thank you. And let me just posit a question at this point to, I guess to John and Kara and Sarah, Town Council, Director of Planning, Community Development, and our ADA Coordinator. What is the status of, what kind of finding has been made to this point regarding reasonable accommodation?
Jeff, are you talking about 40
Yeah.
Beverly specifically?
Pardon me?
I didn't quite understand the question. Are you talking about 45 Beverly specifically?
You know what? I am, and I'm going to withdraw my question because I think we should talk about that in executive session. Sorry. Okay, next, sorry, go ahead, Tina, with public comment.
Sorry about that. Hit my mute button. Carolyn Thal is up next.
Thank you. Hi, Carolyn Thal. I am a town meeting member in precinct 16. So I appreciate Linda raising the notion that perhaps abutters of 45 Beverly, which is in my precinct, should have been notified. So I'd like to ask that question. were abutters notified of the possible vote to lift the stay today? And can anybody comment on whether they should have been? I would agree that instinctively it feels like abutters should have been notified. That's a question. And then I have a comment as well. Thanks.
Well, go ahead and make your comment, please.
Okay. I guess I wanted to, and again, I'm not sure if this should be more under item 3 of the agenda, but it's confusing because you're taking public comment after the executive session specifically about 45 Beverly. And I think this ties to some of what Linda was just saying, especially at the end. John Bouchette in the opening earlier stated that zoning relief is not required for the whatever is proposed at 45 Beverly. And it's not clear to me how that determination could be made based on what's been submitted, at least what is posted with this meeting agenda. There's an insufficient site plan that doesn't include any notes about zoning that you would expect, showing setbacks, etc. And there are some sketches of a building. They're not architect's drawings. I don't think they were produced by an architect. I could do those drawings.
Ms.
Yes.
Thal, I'm really sorry, but these are the sort of specific things that I think we're going to get into when we're specifically addressing the case. And
okay, thank you. I guess I'm just responding to John's comments at the beginning that this project doesn't require zoning relief. So generally speaking, in terms of this whole process and the rules and regulations and the notion of preservation sort of ceding their authority elsewhere in terms of making a determination, I'm interested in understanding how the determination is made as to whether zoning relief is required at this point in a process. Thank you.
You're welcome.
And I would appreciate an answer to the question about notification of abutters. Thank you.
So there was no way to mail notices to the abutters due to the emergency nature of the meeting. It was noticed that this was because of the reasonable accommodation request. And the best that we could do on such short notice was to notice all the town meeting members, hoping that they would contact their constituents.
Okay, let's go ahead and please let's try to just focus on if people have comments about the first item, which was revision of the rules and regulations, which the Preservation Commission is not going forward with. And anything specific to 45 Beverly, we will talk about after executive session when we hold the public hearing on that case.
Okay. Next, it's Dawn Oates.
Hi, everyone. I apologize for my appearance. It's 12:30 in the morning in Thailand where I am right now, but I was invited to speak at this meeting. So I'm happy to see that it was called as an emergency meeting. My name's Dawn Oates, and I want to talk about the Commission's obligations under Warrant Article 15 and federal civil rights laws. The Americans with Disabilities Act and Fair Housing Act are not suggestions. They're binding federal law. Local commissions and boards, including this one, must comply regardless of whether the Attorney General has completed their review of a town bylaw. The ADA and FHAA predate this article, and they have always applied. You are not permitted to wait for local ratification to enforce what federal law already requires. The delay in revising the Commission's rules and regulations sends the wrong message that local process takes precedence over civil rights. It does not. And every day that you wait, the town is exposed to risk. I'll say more risk, not only of liability, but of continuing to deny equal access to people with disabilities who rely on reasonable accommodations to live in their homes. I also want to respond to the discussion about privacy versus public purpose. There is no tension here. The ADA and FHAA exist to protect the civil rights and privacy of disabled individuals while allowing them equal opportunity to use and enjoy their homes, and that is the definition. It's not absolute necessity. It's equal opportunity to use and enjoy their homes. The public purpose of a preservation bylaw does not supersede the federal mandate to accommodate disability. In fact, the ADA requires local governments to modify policies, practices, or procedures when necessary to avoid discrimination. The notion that an abutter's right to be notified should outweigh a disabled resident's right to live safely and accessibly in their home reflects a misunderstanding of both law and of ethics. In fair housing cases across the country, courts have found that requiring notice to neighbors or public hearings can be a form of discrimination, especially when it subjects personal medical needs to public comment, which we've already heard here, inadvertently, delays necessary modification, or chills the exercise of protected rights. There's no legal basis for requiring detailed plans in order to determine whether an accommodation is necessary or reasonable. The law requires an individualized assessment based on the person's disability and the functional necessity of the accommodation, not arbitrary design thresholds. This commission must not use vague standards to delay compliance or impose procedural hurdles that defeat the very purpose of the law. Warrant Article 15 exists because the town's current processes have failed disabled residents, including my own daughter, for 5.5 years still. It was passed by a supermajority to fix that. I urge the commission to bring its rules into immediate compliance with both Article 15 and with federal law, not only because the law demands it, but because people deserve to live in homes that work for them. Thank you for listening. I'm happy, Attorney Ross, I know we know each other from our past. You are welcome to call me at any time. I'm very easy to find online. I'd be happy to discuss my experience with you if it can benefit your clients. Thanks, everyone.
Thank you.
Okay, we have one more, Regina Frawley.
Hi, can you hear me?
Yes.
Okay. Hi, I'm a town meeting member also from Precinct 16, and I was not notified as to this meeting, an emergency meeting, except through somebody informing me from within the precinct. So somehow I fell through that crack. I don't know why this is called an emergency. That would be something I would think matters a great deal for public process. I first want to say, truly want to say, you're my favorite committee. You really are. I've been watching you for 25 years. I used to come in person when you were in person. You guys are, even when you transition and there are other people, you really care about the spirit as well as the letter of the preservation bylaws. And you seem to really care, and that matters a great deal to me. Where I'm from South Brookline, it's not uncommon for people from North Brookline to pay no attention or even be able to find us in South Brookline. I've heard that too. But that said, I am very concerned about the first item, the policy, because of what I just said about my admiration for you. You guys do balance, and you usually almost always include the public comment to be a factor in your deliberations. I would hate to see that to stop. I hate to see a technocracy be even further created by turning major decisions about the quality of our lives over to staff. And I repeat, even staff may not quite know what my neighborhood's about. It wouldn't be the first time. They need to hear from us, and ultimately you need to hear from us. And I would be deeply concerned if, as you go forward with the policy discussion about this, if you were to restrict it as the licenses have been restricted to internal decision-making, et cetera, et cetera. The net result has already proven fewer people participate from the public. It's just human nature. We're further removed from these Zoom meetings that very few people really participate in, and certainly not in my generation. I'm in my 80s. It's a learning curve, and I even have a constituent who doesn't have a computer, and she has a PhD from Harvard. So it happens, and we need more and more ways to get in touch with more and more people. I am concerned that this was called an emergency meeting and that the abutters were not notified. And you cannot rely on the other town meeting. If I didn't know about it until this morning, others, I could not have notified anybody, go knocking on doors. So anyway, I just want to reiterate, you're a great board. I hope you stay with your role in all the decision-making. And that applies to one more thing that does involve the Beverly Road. Your awareness and concerns about the new bylaw being gamed, taken advantage of, it's going to be a reality. I get calls almost every week and letters in the mail asking to buy my property by investors. We're we're losing that sensation of community. And you're kind of one of the only guardrails that some of us in our neighborhood are relying on. So I really hope you keep that in mind, and thank you for everything you always seem to do to help protect the town from bad decision making. Thank you so much.
Thank you. Is John's hand raised?
No, I don't think so.
Oh, okay. Well, it is, but that's okay. That's all-
That's the end of public comment, Elizabeth.
All right. So now, maybe John, as long as I have you, you can advise us about the mechanics of going into executive session.
Sure. A couple of things. It has to be by roll call vote. You have to state the reason that you're going into executive session, which in this case is because the discussion will implicate, I think, some of the personal details of a person's physical condition. And you also need to inform the public that you are going to reconvene in open session after the executive session.
And, all right. So we'll take the roll call vote, to go into executive session. The reason being that we are going to, receive information about a case involving reasonable accommodation, which will touch on the privacy concerns and the, perhaps details of a disability of an applicant. And I'll take the roll call vote, and then we'll remind the public that we'll be coming back into public hearing after that. So I will move that we go into executive session to consider private matters relating to a reasonable accommodation case. So I make that motion. Do I have a second?
I'll second.
Thank you. Now we'll do roll call. I vote yes. David King,
Yes.
Elton,
Yes.
Arisa,
Yes.
Peter,
Yes.
and Brooke.
Yes.
All right, so we will go into executive session and reconvene the public hearing after that. Do we give a time for that?
Yes.
I think you can estimate, that'd probably be helpful for the public.
Can you help us with that estimate, John?
Sure, 20 minutes? Think it'll be longer, 30 minutes?
Let's do 30.
Okay.
All right. So
So
Tina.
that'll be about 2:15, let's say, just to put a number on it.
Okay. Yes. And reconvene at 2:15. And then mechanically, Zoom wise, Tina, what's going to happen?
I need to put everyone in the waiting room.
Okay.
So I will begin to do that now. And
Okay.
folks, you will be automatically, if you stay in the waiting room, you will be automatically let back into the meeting. I'll just push a button and bring you all back at 2:15.
Great. And Tina, just as a reminder that Michael needs to be admitted as well into the executive session.
Yes, okay. I'm not aware of a way to do this without selecting people individually, so I do apologize. It is going to take a minute. I think I am successful. Can someone else just take a look at the list? I think I got everyone. And we have
Is-
Michael Ross is still with us.
And
And
how,
is Sarah Kaplan here?
yeah,
Is she?
she was here earlier.
Where did I? Oh, she accidentally got put in the waiting room. I knew there was going to be a problem. It's too much clicking and the names jump around, so it's impossible to like, yeah. So I'm going to try to pin all of you so that you can be big, but I apologize if it doesn't follow my video order. Whoops. Oh, now I've screwed everything up. Oh, well. You can start talking as
Wait,
long as
don't
you
forget to pause the recording.
Oh, yes, you're right.
Did we need to vote on that, what we just passed?
We'll vote on it in public, in the open session.
Okay, we have one more person still trying to get out of the waiting room here. Okay. Oh, no, there's more. Sorry. Okay. The waiting room is empty now. Everyone's back in the meeting.
All right, thank you for your patience. We're sorry that went over a bit, but we were actively discussing things the whole time. Now we will reconvene the public hearing as to 45 Beverly Road and the applicant's request for a lift of stay due to reasonable accommodation. I think because we spoke about this, in executive session, John, do you have a suggestion about how to proceed, whether to go straight to public comment?
Yeah, I think probably going straight to public comment is
Okay.
the best.
And Tina, can you kind of remind people of the mechanics of public comment and also a little bit of rules of the road? We, ask that people not just repeat indefinitely. If they agree with people that have gone before, they can reference those. And let's give everyone 3 minutes.
Okay, so members of the public, if you wish to participate in public comment for the lift of stay due to reasonable accommodation at 45 Beverly Road, this is that opportunity. You can use the raise your hand function that is located in the toolbar at the bottom of your screen. You may have to hit the heart-shaped react button depending on the specific device you are using. Sometimes their hand is inside the heart, hidden. Alternately, you can message us in the chat and we'll see your name there and we'll call your name. We will call people in order that the hands are put up or the messages are received. And as Elizabeth said, we ask you to limit your comments to 3 minutes and to keep your comments focused on the case at hand. We do have a couple of hands up. Linda Olson Pelkey is the first.
Thank you, Tina, and members of the commission. I do feel at a great disadvantage since I was not privy to your conversation, but I would just say that even without hearing what was presented to you as the facts of the case, I would ask you to ask yourselves whether or not you feel confident that demolition is the only option in providing a required accommodation in this case. I think that's what you have to find. And, you know, when we were debating this in prior to town meeting, as you know, I'm a town meeting member, a member of the advisory committee who vetted these warrant articles. We, you know, tried to contemplate how are people going to decide the question of, and who is going to decide the question of, does granting the accommodation fundamentally cause us to deviate from the purpose, the public purpose of our bylaws and regulations? And it's really hard for me to imagine a case, I'm sure there is one somewhere in the world, where a house must be demolished to provide an accommodation. But to me, that is the poster child of a case that would be asking the town to go further beyond and to negate the purpose of our bylaws and regulations, if that makes any sense. So I am opposed to granting a lift of stay at this point. But as I said, I do not know what you heard and what you might be basing your decision on. But it does seem a completely draconian and extreme measure to make that claim. And I just would ask that you be very skeptical about that. So that's the extent of my comments. Thank you.
Okay, the next hand up is Carolyn Thal.
Thank you. I'll just state again, Carolyn Thal, town meeting member, precinct 16. Since this is a separate conversation, I will reiterate the concerns noted before about the lack of notice with this issue and potential vote. I think that's troubling, and I hope that's a consideration, but more specifically, and following the conversation about how you are trying to align future rules and regulations to promulgate new bylaws, should they be approved by the AG's office, and specific to this. You know, the Preservation Commission made a very clear decision in June to protect this home for several reasons. So I would be very disappointed if at this point you deviated from your established processes and rules and regulations and the purposes and protections of our bylaws. This request would fundamentally alter the nature of the public process, because you would be effectively giving this applicant carte blanche, totally absent proper documentation, related reviews, including stormwater management, which I'd be happy to talk about if I had more time. And that would be extremely problematic. Again, going back to John Bouchette's comment earlier, and I don't know if you talked about this in executive session, but the comment that this project does not require zoning relief. It is not clear to me how you could possibly make that determination, or that anybody could. There are not legitimate plans, site plans, building plans for this, whatever would be proposed. Hopefully members of the commission and others also had an opportunity to read written comments that I submitted.
And I'm very concerned about as we've all talked about, balancing the various needs, including the very fundamental integrity of our bylaws and the processes and purposes of this commission. So I sincerely hope for all of those reasons that you stay consistent with the decision made in June. Thank you.
Thank you.
Okay, the next hand up is Dawn Oates.
Thank you. Excuse me. All right, so I'm going to assume that your discussion landed in the right place. And I'm going to not repeat myself, but I want to remind the board and the public that the request before you to lift the delay in order to build an accessible home under the Fair Housing Act and ADA, it's not a matter of taste or policy preference or public consensus. It's a matter of federal civil rights law. Under the Fair Housing Act, the legal standard for reasonable accommodation is very narrow and non-discretionary. You have to ask only 3 questions. Does the person have a disability? Is there a nexus between that disability and the requested modification? Is the request both necessary and reasonable? And there has been a lot of conversation leading up to bylaws 14 and 15, or warrant articles 14 and 15 rather. What does that mean? Necessary means the accommodation must afford the person with a disability an equal opportunity to use and enjoy their home. Not a better one, not an ideal one, a meaningfully equal one. Reasonable doesn't mean we think it's reasonable. It's not an opinion. It doesn't impose an undue financial or administrative burden on the town, and it does not require a fundamental alteration of the zoning scheme. I'm going to get back to that in a minute. These are legal terms. They're not matters of personal opinion or public comfort. So if you ran this decision that you made tonight in executive session through that narrow legal framework, you would have likely come up with the right answer. Furthermore, you're not legally required to wait for finalized architectural plans before lifting a discretionary demolition delay. The courts have made it clear that imposing excessive procedural hurdles constitutes a denial under both FHA and ADA. There's case law about that. And here's what's critical in this specific case. Accessible housing is nearly non-existent in Brookline and across the country. Those who know me know that I lived in a construction site because there was no home for me to live in with my family of 5 and 2 dogs during the pandemic. We lived in an active construction site. There was no wheelchair accessible housing. Nationally, less than 1% of housing is both wheelchair accessible and includes features like 0-step entry and accessible bathroom facilities. In Massachusetts, those numbers are equally dismal. If you allow the demolition and you approve this accommodation, regardless of whether you think someone's gaming the system, Brookline will gain just 1 more accessible home in a town where the overwhelming majority of housing stock remains inaccessible to people with disabilities. To delay or deny the process is not neutrality, it's discrimination. Brookline's demolition delay is a discretionary preservation tool designed to discourage change. But federal disability law is not discretionary. Once the person demonstrates that the accommodation is necessary and reasonable, the law requires it be granted. You cannot require counterbalancing amenities, public negotiations, or aesthetic compromises that hide disability or segregate people with disabilities from full inclusion in the community. A public deliberation on a person's disability-related needs, especially in the absence of any detailed plans, is a violation of their privacy and their dignity. It undermines both the spirit and the letter of the ADA and the Fair Housing Act. So I hope that the board has voted to lift the delay or will vote to lift the delay tonight. There's really no legal basis to continue it, and there's no authority to subject a federally protected accommodation to local gatekeeping, and that's what this is. There's no justice in denying a family the right to build the accessible home that they need to live with full dignity and access. That's all I'll say for tonight. If anyone wants to contact me offline, I am open to that. As you know, I am a disability advocate. I've been doing this for 13 years. Thank you for letting me speak tonight.
Thank you, Ms. Oates.
So the next person with their hand up is Regina Frawley.
Hi, thank you again. Obviously, as Linda said so well, we're not privy to what went on behind closed doors. I've heard certain things that probably were included in your discussion, but there are others I'm sure were not. I have multiple health issues. I don't think you, and I agree this much with Dawn, that you don't have a right to know what my issues are, but you do have a right to know whether or not I'm legitimately claiming it in good faith when I ask for accommodations. I would trust that you would protect your own existence by insisting on that kind of internal proof that would be comforting to you to know that this is a legitimate good faith request.
Miss
I
Frawley,
also-
Miss Frawley, I'm sorry. I'm very sorry to interrupt. I just want to reassure you that the ADA coordinator for the town of Brookline has verified that information. We don't need to go into it in
Okay.
any detail in the public hearing.
Okay, that's wonderful to hear. And I trust Sarah implicitly with her devotion to her assignment. That case, nonetheless, and I can't say about this particular example, but we can expect multiple examples to start coming up. I was recently at a meeting of the Town Meeting Members Association, and the town moderator said that more than 60 people, town meeting members, requested an accommodation of Zooming the meeting and not attending it in person. That stretches my credibility 100%. It's most unlikely that that was the case, but people didn't feel like showing up in person, so they didn't. And there was no fail-safe. There was no way of checking whether any of that was legitimate.
Regina,
Miss
please
Frawley,
don't speak about other people's disabilities that you have no information on.
yeah, and Miss Frawley, the tenor of this, we don't want this to descend into worrying about people, quote, gaming the system. We're here on a specific case, and let's keep the discussion confined.
I think
to that.
though, yes, I think that the specific case, again, we're denied all the information, but it can become the poster child, as somebody said, the test case, because at some point it will end up in court. I hope that this is not one of those examples, but I do hope you factor that reality in your decision making. Thank you.
Thank you.
Oh, sorry, Elizabeth. I wandered off. There are no more public comments at this time.
All right. Thank you. Thank you for your patience, members of the public. And so now we will proceed to discuss this within among the commissioners. I'll just acknowledge that, we were in executive session and we discussed this, and I know that's frustrating for the public, but there are very legitimate reasons for boards and commissions to need to go into executive session, and this was one of those where the privacy of a person with making a request for a reasonable accommodation needed to be protected and respected. I think I just want to say one thing about, several people have talked about the desire of the abutters to be able to weigh in on cases involving reasonable accommodation. And we talked about this, well, never mind. I'm not going to say what we talked about in executive session. That's not the way to go. But I will just say, this is an area where federal law preempts local law. And, I don't expect that to mean to you what it means to me, because I've been a lawyer for 35 years. But federal law states a broad policy that is more important than local law. And that rubs up against people's sensibilities in a number of different ways. And the opportunity for abutters to be notified and to weigh in and to be heard in public meeting is compromised. That's at odds with the federal law, which preempts local law. I see people shaking their heads. You don't have to like it. You may not want to pay your income tax. That's also federal law. So I just wanted to address that specific concern because it's been brought up another time, a number of times. All right, so other commissioners, what do you, who would like to speak? Elton, you're muted.
I was actually hoping not to speak, believe it or not. But can you tell us where we are in this process? Because we, of course, we have discussed the specific case. Are you looking for somebody to state where we've got to after that discussion?
Sure, but I'm gonna suggest it not be you because you sound like you're underwater.
Absolutely fine.
All right.
So I'll introduce it, but I won't introduce what I think is the motion. But
Okay.
So I think we agree like that in terms of an ideal process, there's a lot that's wonderful about this existing home. And from some of the architects in the committee, we've looked at this carefully to say, this could be made accessible. However, as has been noted multiple times, that's not what this is about legally. And instead, we were trying to make sure that we were addressing what we felt was a reasonable accommodation. And so much of the discussion was ensuring that this new home would be fully accessible and providing a little bit of commentary on that and ensuring a process that would, if this was not able to, in the current process for the owner be a renovation, that the new building would meet a level of scrutiny that would allow us to say this was in fact a accessible new construction. So I think our motion was developed based on that to basically provide us with an ability to lift the stay based on the measured reasonable accommodation and what we could understand to be acceptable, and allow the commission to basically lift the stay, allows the appropriate body to make the determination of meeting a requirement relative to the Massachusetts 521 CMR accessibility language to provide guidelines for refining the design of the home. And so I think that's kind of where we ended up, and that's not quite a motion, but that gives some background to the process that we went through.
Thank you, Peter.
Do we have a transcription of, or did anybody actually write down the language we came up with so that we can just read it back and start from there?
So I have got it together in a Word document as best I could. Do you want me to share that now, Elizabeth?
Sure.
Okay. Okay, so this is small. Let me see if I can make it bigger.
There's a zoom in the bottom right corner.
So do you just need somebody to read it?
Yeah, just read it. That's fine.
Okay. So I move that we lift the stay based on the condition that that stamp plans in compliance with Massachusetts CMR 521. Section 9, which is for residential units in multiple buildings, be provided, and the plans are to be submitted for the review and approval I think what we said was of the building inspector, not the Preservation Commission.
At the end of that discussion, Elton was designated as the person to review it, but maybe the commission should discuss briefly.
Were we getting notified by the building commissioner?
He will have to notify us back after we review that, I guess. Yeah.
Yeah, Tina, this doesn't comport with my understanding exactly, which is not surprising given, you know, an oral discussion like that. So my understanding was that the architect for the project is the person who would, review the plans and stamp them.
Yeah,
And
that's the
that's
first
implied
sentence.
in the first sentence, that they have to submit stamped plans. That's their architect.
Okay, and those would be submitted to the building commissioner's department. It's not clear to me that he's the person who needs to approve them, but they'll be approved by the building department. And I did not understand, I don't remember that did we say that a preservation architect was going to review them? I did not think we said that.
I think what we said was that the building department would review the submitted plans for accessibility, and that they produce a checklist and a letter explaining if they approve these plans as accessible. They submit that to the Preservation Commission. Me personally, would be reviewing that letter and that checklist.
I think that's correct.
Yeah, I believe so.
Thank you. Friendly amendments on the fly.
I'll second it if we're there.
I think we're not quite there.
We're not
Okay.
quite there.
I'm just hopeful.
So there was a suggestion by Kara at the end of our discussion that there should be some condition on this approval, much like we have in the normal lift of stay process, that certifies that the plans that we review and approve are the plans that are built. So the commission should discuss whether they will require that.
I thought that we talked about that, and I think this case, like any other case, at the point of lift of stay, they'll have stamped plans, and that I believe the discussion was that we should not require anything extra or further from them than we would from any other applicant.
Oh, well, I just explained that we do require that of
Yeah,
other
I think
applicants.
I think that is to say that there's a one person empowered subcommittee that is reviewing. So it's consistent with the language you have, right?
I would like to not use the word subcommittee because all
Yes.
subcommittees are subject to the public process.
Correct.
Let's not do that.
But once the lift of stay will be entered administratively upon the Preservation Commission's architect, Elton Elprin, reviewing the documents from the building department.
But I think we should include what Tina was saying she normally does.
Why do we have to write down what's normally done? I mean, that's what always happens. Why do we need to put that into a motion?
Because in this case, reasonable accommodation is waiving our normal process. So I do think we need to specify what elements of our normal process we expect to be upheld.
Okay.
So do we say, lift to say contingent on revised plans? Revised stamped.
I don't know if we need to use the word revise, just.
Okay, fair enough.
I think we should just say plans as described above. Not revised plans, because the lawyers.
Just get rid of the last sentence. were
You don't
basically
even
s-
want it.
No, we were basically saying the lift is contingent on stamped plans that are compliant with. And it would just be Massachusetts, CMR, CMR 521 or 521 CMR. So yeah,
Yeah, do you want me to change this to contingent
yeah,
like
sure.
that?
Yeah.
That's more clear.
And in the second to last sentence, I would say confirm the plans are accessible, not construction.
All right, Peter, do you want to make your motion again?
Okay, I'll make a motion that we lift the stay contingent on stamp plans and compliance with Massachusetts standards, Massachusetts 521 CMR, Section 9, which is for residential units in multiple buildings. These plans will be submitted for the review of the building commissioner, who will review and confirm compliance with Massachusetts 521 CMR Section 9. This decision will be approved by an architect from the Preservation Commission who will confirm the plans are accessible per the building commissioner's decision. These approved plans will be stamped, approved by the preservation staff, and attached to the building permit per the normal lift of stay procedures.
Who would like to second?
I'll second it.
All right, we'll vote. I vote in favor.
I'm sorry, is there any opportunity for further comment prior to?
No, not, this is with the commission now. All right, I vote in favor. David King,
Yes.
Elton,
Yes.
Arisa,
Yes.
Brooke,
Yes.
and Peter.
Yes.
The motion is unanimously passed. I think that concludes the business on the agenda.
I'm sorry, again, I'm a town meeting member and I would love the opportunity to just make another comment. Is that really too much to ask?
Go ahead. I do note you've already commented twice, both you and Ms. Pelkey, but I don't mean to be rude about it. We normally, when we're doing a roll call vote, we don't take further public comment and further discussion when it's with the commission and we're voting on the matter. So yeah,
That's fine. I understand.
Yeah,
I'm
okay.
also a school committee member, so I'm quite familiar with how these things work. So it's just that you took public comment before the discussion, so your discussion sort of informs a bit more thinking. I did want to respond, Ms. Armstrong, to your comment that that abutters were, in your view, not entitled to notification of this meeting because it was about reasonable accommodation. But the vote was to lift the stay, and that is what you have just voted to do. So the abutters, I can promise you, will be shocked and dismayed to learn that this happened. And I think that I'd like to note that you can anticipate an open meeting law complaint about both the agenda and the failure to notify abutters. And what you have just done has confirmed exactly the fears. You are giving this applicant carte blanche to build whatever they want. There is nothing in your motion about not requiring zoning relief. There is nothing in your motion about other conditions such as stormwater management, which I'm sure you can check with the DPW and water department, has been an acute issue.
This committee is not
at that-
responsible for those approvals. There's no way that we can issue decisions on them.
Okay, I guess then I don't really understand because it says, because what you're saying you're going to do is allow them to demolish this house based on whatever they submit to the building department. So it's very loose. It's extremely problematic. It will continue to be problematic. It is not going to end well. And I'm extremely disappointed and distressed. And so will be my constituents and these abutters who were entitled to be notified that you were going to vote to lift a stay of demolition. So again, you can anticipate complaints next week.
Ms. Pelkey?
Yes, well, I didn't think I was gonna get a chance to speak. I also think this decision will be challenged because I heard Mr. Kleiner say that the existing house could be made to accommodate the individual. And once you've admitted that, then you've made it not necessary to demolish the house. So I honestly can't fathom what it is you're thinking. So, and as far as the future plans, I mean, there are other conditions such as to be a reasonable accommodation, the person who requested it has to be living in it. Is there any condition that for this action, for that to be the case in the future? Are they gonna sell it again to somebody else? We don't know, and you haven't controlled for that. So, yeah, I think you have made a very unfortunate decision here that I think is based on faulty understanding of the law. It is, you know, we spent many, many, many hours with the lawyers discussing this, and we did not hear that no other considerations can be made, that we can't try to accommodate the needs of the town as well as the individual. As a matter of fact, we heard many examples of bylaws and cases where they were, and it was acceptable to the AG and the state and everyone else involved. So these assumptions that there's this hard and fast rule, this bifurcation that we cannot consider anything on the local level is just absolutely not true. And I'm surprised that you didn't hear that from town council. So I just find this all very unfortunate, and it doesn't bode well for the future. And I think we need to fix this as soon as we possibly can by drafting something else and adopting it.
All right, thank you, Ms. Pelkey. And I'll give Ms. Oates an opportunity to speak, and then I think we'll wrap up for the day.
Okay, great. Thanks a lot. Just to address a couple things that people have said, under federal disability law, once a person demonstrates that they have a disability and that there's a connection between that disability and the requested accommodation, and that it's necessary to afford equal enjoyment and use of the home, the accommodation must be granted unless the town can show undue burden or fundamental alteration. Once the town shows undue burden, if the town does not show undue burden, only then may they, excuse me, I got to back up. Only then, if it's an undue burden or a fundamental alteration, only then may the town engage in the process to identify a less burdensome alternative that still meets the individual's disability-related needs. And so that should answer the questions that have come up. You cannot just say, this is what the person asked for. We have to give the benefit of the doubt, the spirit of ADA, that a person with a disability knows best what they need and what is going to let them best use and enjoy their home. We can't say, well, we could do something different, because that would open unlimited possibilities. The town can't use this as a pretext to delay or water down the request. Any modification must be least restrictive and still provide meaningful access and equal enjoyment. The town can't deny or modify simply because it's unpopular, it's visible, it's inconsistent with aesthetic norms. The town can't add conditions that amount to burdensome counterbalancing amenities. I might have said that earlier. They can't demand documentation beyond what's necessary to establish disability nexus and necessity, and they can't require waiting for finalized plans. Basically, it keeps coming up over and over again. It came up in something like 17 meetings that we had. It came up a bunch of times. The town can only propose modifications to the plans that are requested if it determines that granting the accommodation would result in an undue burden or a fundamental alteration to the town, and it engages in a good faith interactive process with the petitioner, in this case with Mr. Ross, to find a viable alternative that still meets the disability related need. And it would be involving that family or that person who's petitioning to have the accommodation. That's something that has been largely missed in all of the discussions that we've had from the minute that I submitted warrant articles 14 and 15 right up until today. I'm still hearing it. I would really urge people to look into the law. As for the town meeting member, Carolyn, I believe it was, I would just suggest that before you sound the alarms with your constituents in your precinct, that you do look at the Attorney General's municipal law database. There are many, many cases where the Attorney General, Andrea Campbell, and also going back to Maura Healey and before that, where she routinely turns away language in bylaws that have passed at town meeting because they reference having public meetings and public notice to abutters. It could have the impact of inviting discriminatory animus. It can have the impact of chilling future participation in due process or seeking accommodations that are necessary by people with disabilities who need them. There are many, many reasons, and oftentimes towns don't know that. And that's the situation that we found ourselves in this year.
Miss Oates,
That's all I really wanted to say.
Oh,
So.
okay. Thank you very much.
The issue was the lifting of the stay, not the reasonable accommodation.
All right. All right.
I need to sign off.
I'm going
Thank
to,
you.
bye, Peter. I'm going
Goodbye.
I'm going to adjourn
clear.
the meeting.
The point
and
is
invite
disability
other
purposes.
people to
Elizabeth, you are muted because I muted everyone. Can you unmute and adjourn this meeting?
I'm adjourning this meeting at this time. I invite people who have further comments to write to the Preservation Commission or to town meeting members. Thank you, everybody, for your participation.
Okay. Bye, everyone.
Bye-bye.